A very good morning to dear students. As we have completed the Jurisprudence 2 syllabus, now it is necessary that we revise from the first topic so that those who were not able to understand it while the lectures were going on in the classes, or those who still had any problem, the concept would be clear with much aspect here, and then we will do necessary assignments and case laws discussions, or wherever necessary class assignments, class notes, so that you must have the clarity of all the topics before you appear for your external exam. So this is a revision lecture on the first unit of Jurisprudence 2, that is legal person, nature and concept. So let's begin our lecture. Let's first start it with the definition of person. Now see, the main object is of law is always to regulate a relationship between individual and society. We say that law are the rules and regulations which are being created or enacted by the state, and for whom these laws are being enacted, for the people or for the individuals in the society. So always there is an object of law, that there must be a relationship between individuals in the society and a law. Now, the law is being concerned with regulating the conduct of a human person, human personality, in the aspect of whatever rights and duties that person would be following. So when we talk about a person is an individual who is an ambit, or who is an institute, or who is an, you can say, an attribute of the society, and that person follows the conduct of human, have the concept of legal personality, and with this it consists of rights and duties. So we can say there are no such person who will not have any rights and duties. So when we talk about the jurisprudential aspect of legal personality, we come to a point that legal personality constitutes a very important aspect of jurisprudence, because there cannot be any rights and duties without a person, which means if rights and duties are there, and if we do not have any person or an individual to follow those rights and duties and law, we cannot say that there is a jurisprudential aspect of legal personality. So now let's first begin the definition of the person given by various jurists. Now there have been many definitions of the person given by various jurists. We'll discuss the four definitions of Salmond, Savigny, Gray and Austin. Now Salmond defined a person is any being whom the law regards as capable of rights and bound by legal duties, which means Salmond say a person is a being, a human being to whom law has given the rights and is bound to follow the legal duties. The Savigny defines the person as subject matter or the bearer of the right, which means Savigny say that the person is the holder of the right, the one who is having the rights and duties. Gray defines a person is an entity to which rights and duties may be attributed, which means Gray said that the person is an entity or as an institution or is a body to whom rights and duties can be given or can be attributed. Now, when we talk about definition of Austin, Austin say the term person includes physical or natural person, including every being which can be deemed to be human being. So Austin say that the person will include all the kinds of physical and natural person who can deem to be a human being. So with the definition given by four jurists, we come to a conclusion that person simply means any kind of a human being, or being a human, or a person to whom, or a subject or an entity upon whom the rights and duties can be enshrined or can be given. Let's now discuss the nature of person, which means as the definition of person is there, whether there are kinds of different persons or not. Personality in a philosophical sense simply means rational substratum of human being. In law, it means right and duty bearing unit, which means an entity which have rights and duties. Personality should be distinguished from humanity. Now, humanity is something else and personality is a different aspect. Humanity means only natural human beings, but personality has a technical meaning and it includes inanimate objects. Thus, personality is wider than in humanity. When we can say that humanity is only restricted to natural human beings, But personality is one which is restricted to natural human being also and inanimate objects. Sometimes humanity and personality coincide, and sometimes they not. There are human beings who are not persons in legal sense, such as slaves in earlier times. In the same way, there are legal persons who are not human beings, such as an idol and corporation. Now, corporation is not a human being, but it is an artificial juristic legal person. Similarly, now let's divide persons as of they are two kinds. Number one, natural person. Number two, legal or artificial or juristic person. Now, there are some natural persons who do not enjoy the status of legal person and vice versa. We'll discuss the legal status of person in detail in the next part of this lecture. Now, let's start meaning of natural person. A natural person is legally defined as a living human being. So, natural person simply means a living human being person, which means I and you are a natural person. A natural person is being to whom law attributes personality in accordance with the reality and truth. Legal person, according to Salmont, is any subject matter other than human being to which law attributes personality. Legal person simply means those person who are other than human being, but which means they are not human being, but they have been recognized as a legal person by the law personality attributes. It includes object, mass of property, institution, group of human beings, etc. Law treats them as a personality who have rights and duties like a natural person. It is a fiction of law that they are treated as person. Law in creating excuse me, legal person personifies some real thing or object and then confers upon it a fictitious personality, which means legal person is simply a person who is other than human being with whom law has recognized him and have given attributed him with rights and duties. It can include mass of property, institution, corporations, idol, mosque, or any another aspects which have an entity of bearing the rights and duties. Now let's discuss the origin of the concept of legal personality, which means how this legal personality has originated. The word person has been derived from Latin word persona, which means a mask which is worn by actors playing different roles in a drama, which means person has been derived from a word persona, which means wearing a mask, and we have different duties and rights which we are performing as our role. Until 16th century, the word was used to denote part played by a man in life. Thereafter, it began to use in the sense of living being, capable of having rights and duties. Many writers have restricted the use of the term personality to human beings, and alone it can be said to subject matter of rights and duties, and then the juristic personality. But it has been wider. See, many jurists have extended that person is restricted to a natural human being, but with wider use when the aspect of law, it included that God and angels, idol, corporations are not human beings, but they have the characteristics of living personality. That is, they have certain rights and duties, and therefore they can be treated as an artificial juristic person. Likewise, Hindu law, an ascetic sannyasi who was renounced the world ceases to have any proprietary rights. Entire assist has been passed to his legal heirs. However, with development and advancement of society, it was realized that treating only human beings as person in law would lead to good deal of needless perplexity, which could be avoided. Thus, emerging concept of artificial legal personality in jurisprudence is the new discussion over the topic. So the point is there, many jurists said that a person is simply a natural human being who have rights and duties. But later on, with development of law, it came to the point that only person, natural human being would not be a person, but a person can also conclude of artificial juristic person whom law has recognized and given him the rights and duties. Similar aspect we studied that person has been derived from Latin word persona, which means a person is wearing mask and performing its various rights and duties, acting in a different role in the aspect of law. Let's move on to the next concept, that is the legal status. We studied that apart from human being, different idols, corporations, animals, dead bodies, dead persons also have a legal status. So how these legal status have been determined, how they are determined as a legal personality, we will now discuss in excuse me, detail. Legal status of unborn child. The law attributes legal personality to an unborn child. It says that a child in mother's womb, by fiction of law, who is not treated as unborn and has the right of a legal personality. So any gift to a child in his mother's womb would be treated as a legal person, and all his ownership and rights can be given. So which means a child who is yet not born but it is in mother's womb is treated as he is born, and he or she has the attributes of a legal personality, and therefore any rights, ownership, gift can be named in the place of him. This provision is present under Section 13 of Transfer of Property Act, Section 114 of Indian Succession Act, Section 315 of IPC, that is Indian Penal Code, and Section 416 of CRPC, that is Criminal Procedure Code. That is the status of an unborn child. Next is the legal status of dead person. Dead man is not a legal person, which means as soon as the person dies, his rights and duties ceases to exist. Dead men do not remain as bearers of rights and duties. It is said that they have laid down their rights and duties with their death. Action personalis moritum cum persona, which means action dies with the death of a man. Now, when dead personality comes to an end, a dead man ceases to have any rights and duties. Yet, law to some extent has taken the account with the desired intentions of the deceased person. Law ensures that a dead person have a right of decent burial, a decent right of disposal of his property, which would protect his reputation, and any case pending in his name should be instituted by the person of his decease, which simply means that when a person dies, he dies with all his legal rights and duties, gets seized off and taken away, which means with the death of the person, the action also dies. But law recognizes that the dead person have certain rights and certain obligations which need to be followed, wherein it ensures that he have a decent burial, it respects the wishes of the deceased, which means his property is disposed of properly, his reputation is being protected, and any case pending upon him would be taken up by his legal heirs, which are proper disposable of his cases. So the point is that yes, a dead person also have a legal status in aspect of protecting his rights. Let's discuss it with a case law. In Ashray Adhikar Abhiyan versus Union of India, it was held that even a homeless person, when found dead on the road, has a right of decent burial or cremation as per his religious belief, which means till he is buried, till his property is disposed of, in any case, he has a proper right over these aspects that it need to protect his reputation. So which means a dead person also have a legal status. Let's move on to next point, that is legal status of animals. In the present day context, the animals are deemed to be incapable of having any legal rights and duties. They are merely the things, often objects, but they are never subject to them. For example, a beast has no legal personality, but any harm done to the animals be a wrong to its owner and the society as a large, but it will no wrong to a beast. But the animals have two rights that need to be protected. That is, cruelty to animals is a criminal offense, and a trust or benefit for a particular class of animals as opposed to for individual animal is valid and enforceable as a public and charitable one, which means animals do not have any kind of rights and duties. But if any harm is done to the animal, that is a harm which is done to its owner and to the society at large. So we can say that animals have two kinds of rights which need to be protected. Number one, any cruelty done to animals is punishable as a criminal offense. Any kind of a trust which has been opened in the name of class of these animals or individual would be enforced, valid, enforceable, and would be treated as a public or charitable trust. Now, next is the legal status of idol and moss. It has been judicially held that idol is a juristic person and it can also hold a property. However, its position, like that of minor and the priest and pujari, has taken place, and which came to the aspect that idol kept in a temple is a juristic person. It has a right to hold a property, and minor and the priest or pujari acts as a guardian of these legal status of the idol. Furthermore, it was held that whether mosque is a juristic person or not. So there were two case laws which led to the aspect of the discussion that whether the mosque has a legal status of juristic person or not. Number one is Paramatma Nath Mullak versus Pradhumna Kumar Mullak. It was held that idol is a juristic person and its will as its location will be duly respected. Court directed that idol be represented by disciplinary next and friend to be appointed by the court to look over this. This was the case law wherein it was given that idol is a juristic person. Next case law is Mullah Bucks versus Hafizuddin, which held that mosque was a juristic person capable of being sued. But Privy Council in the case of Masjid Sahid Ganj held that mosque is not a juristic person in the eyes of law and no suit can be brought. So this question is still open that whether a mosque is a juristic person or not. Still decisions have not taken place in the aspect of defining the legal status of the mosque. But the legal status of idol has been defined and it has been said that idol is a artificial juristic person. So herein we have studied the definition of the person, the nature of the person, that is natural and legal person. Then we have studied how the origin of the legal person has taken place with the aspect of legal status of various legal persons, discussion over legal status of unborn child, legal status of animals, legal status of idol and mosque, legal status of a dead person with relevant case laws and examples. So we understood that a legal person also have a legal status, is also a bearer of the rights and duties, and also have a right over its reputation to be protected, can be sued and be sued. Now let's discuss the theories of legal personality. With that, we will end up this lecture wherein we have completed the nature and the concept. Now, before starting the theories of the legal personality, herein if we are talking about the theories of legal personality, these are also called as theories of corporate personality. So whenever you get a question in your exam regarding discuss the theories of corporate personality, they are nothing but similar to the theories of legal personality. Excuse me. Now let's discuss first, what does a corporation mean? A corporation is an artificial person which group of person by legal fiction are treated as a person and has a capacity of having rights and duties and holding a property, which means corporation is an artificial juristic person. It has the capacity of holding rights and duties and a property. Now, corporation are of two types: corporation sole, corporation aggregate. What is corporation sole? It consists of series of successive person, one member at a time. Example: sovereign, postmaster general, secretary of a state for war, etc. Which means consist of a single person who is personified and regarded as a legal person. Which means there is a single successive of person. One person dies, the other legal hire could be in the place of the corporation sole. When we talk about corporation aggregate, is an incorporated group of coexisting person, which means it has several members at a time. Corporation aggregate simply means a group of coexisting persons, which means single persons at a time. It is an artificial or fictitious person constituted by personification of group of individuals, which means it consists of group of individuals, persons who are incorporated together and hold a aspect of legal personality. Now, when law grants legal personality to a group, it is the nature of entity which thus recognize. Most of the theories of legal personality suffer from a defect that they have attempted to answer this question. It is impossible to discover a common essence that whether the legal person have rights and duties or not, whether that person is desirable or not, whether the nature of groups or corporations have put forward a justification of keeping the law rules or not, whether they have developed with an aspect that they have legal problems arising in connection with the groups or association or not, whether they are in accordance with the nature of the aspect of legal personality or not. So to come out with the importance of the theories of legal person with the practical consequences, whatever is happening in society, let's now discuss the theories of legal personality, or we can also say theories of corporate personality. Number one is fiction theory. Now you can see that the main supporters of this theory was Savigny, Salmond and Dicey. So this theory said that human beings can property to be called person. Same kinds of groups etc. can be regarded as a person as a fixatious law, which means this theory said that you can recognize a corporation as a fiction by law, which means it has created as a fiction by law, and it is a fictitious body which have certain rights and duties. So this theory is most applicable to English law, where the courts have not proceeded on any hard and fast rule according to recognition of juristic person. Basis of this theory is that artificial juristic person has only fixatious will and it cannot commit crimes. So fiction theory main supporter Salmon Savigny Dicey said that a corporation or an artificial juristic person is a one such person who is fixatious by law, which means its establishment is fixatious at will. That corporation cannot commit any kind of a crime. It will have rights and duties, it will have a legal status, but that will be fixatious in nature. It will not be in a present aspect. Next theory is concession theory. This is also in relation to the fiction theory. The supporters of this theories are the same Savigny, Salmon, and Dicey. This theory says that corporate bodies have legal personality only the extent that is given by the law, which means the state. In other words, law is exclusive source or authority which can give juristic personality. This theory states that by leaving the creation of juristic personality at the discretion of the state, it leaves no room for mischief. Okay, so concession theory is an extension of fiction theory. Fiction theory says that corporate personality is the one which have derived its legal status by a fixatious at will, which means it is fixatious in nature. It cannot commit crime. It is just reliable that in a fiction, the personality has been created. The concession theory is an extension of fiction theory. Supporters are the same. Further, they elaborated that yes, corporate personality is fixatious in nature, but the corporate personality derives its personality characteristics by the law, which means if the law, that is the state, recognize that this would be the personalities of the artificial juristic corporate bodies, those will be personality in accordance with the discretion of the state. So there is no room for any kind of mischief. Excuse me. These are the two theories, that is fiction and concession, and the difference is that fiction theory states that a corporation is a artificial juristic person fixatious at will, which means it cannot commit crimes. It is fixatious in nature. Concession and extension of the fiction theory, which says that yes, artificial body or a corporate personality is artificial juristic person, but its personalities have been derived at the discretion of the state, that is the law, which means whatever law recognize their personality, that is the personality of the corporate personalities to the extent of that, and therefore there is a no ground for any kind of mischief. Next is realist theory. The main supporters of theory was Gerke and Maitland. This theory is also known as organic theory. This theory simply says that corporation is not something which is fixatious in nature or which is just in a present scenario or its law has been given by the state. It is a real will, real mind, and real power, which says that corporation have all the characteristics of natural person. It said that the corporation aggregate or soul is a group of persons who work together, who carry out the functions of a corporation. So the point was that a real mind, a real will, and a real power is working behind the corporation. So it has all the characteristics of real natural persons in a real sense, that of human beings. They can also commit crimes, they can also be put behind the bars, and they can also sue someone on the aspect because they are run by the real minds and real will. Those are now no one but the human beings. These are the three theories: fiction, concession, and realist. Let's move on to another theories, that is bracket theory or symbolist theory. This theory says that the members of the corporations have rights and duties, but those members are kept within a bracket, or you can say within a symbol, which means it was said that corporation is run by members, that is real power, real will, real mind, but they are within the brackets and they have rights and duties. Once they commit a crime, they are removed from this bracket, and that is the contention of the theory, that only human beings have personality and not the group. So the point is that these corporate personalities or the members are within a bracket and they are termed as a unit. If they commit any kind, that kind of a crime, that bracket is removed and they are removed out of that personality. So the contention of this theory is that only human beings have personality and not the group as far from truth. In modern time, it is also agreed that corporation has a legal personality which is separate and distinct from its members and different from rights and duties. So according to bracket theory, it was said that a corporation as a whole is a bracket and symbol. Within them, there are the members who are the human beings. Now, these members have distinct members are there and they have different rights and duties. So any failure toward their rights and duties, that bracket is removed and they are removed out of the aspect of the ambit of corporation. Next is Hoffield theory. Hoffield theory gave a distinction between human and juristic person. He said that juristic person is the creation of rules of law. Human beings have rights, duties, and powers. So when they are born, they have rights and duties. So the corporate person is a procedural form, which means it has been formed by rules of procedure, by the law, by the state, which is used to work out in the convenient way of jural relations and postpone detail working out of these relations. So this theory closely resembles bracket theory. It basically says that a natural person or a human being is one who is born with all the rights and duties, liabilities. But an artificial juristic person, that is a corporate, have a personality which has been established by a procedural form, that is the rules of procedure by the laws made by the state. So in that convenient way, they follow their rules and regulations according to those law. They perform their rights and duties according to these law, and they act within the aspect of those rights and duties made by the state. So it is similar to that of bracket theory. Next is Kelson theory. Kelson makes an analytical and former approach to the concept of personality. He rejected the purpose of law, any contrast between human being, natural person, and juristic person. He rejected the definition of person as one which have rights and duty. According to him, the claims of rights and duty is the person in law. There is no entity distinct from them. Turning to corporation, he said that it is the conduct of human beings that is subject to rights and duty. So Kelson said that rights and duties are of a person is simply the one which is distinct from any entity. It has totally rights and duties. And when we talk about corporation, it is the conduct of human beings which are subject to those rights, and which means human beings are the one who conduct those rights and duties, perform those rights and duties, through to which the attributes of legal personalities of corporation have been determined. Thus, to conclude, we have concluded the theories of corporate personality on a point that what is the definition of corporation, what do we mean by corporation sole and corporation aggregate. If we talk about theories, there are 6 different kinds theory. Number 1 is fiction theory, which simply says that corporation is fixatious at will, which means it is not in real sense. By a fiction, it has been created, so it cannot commit crimes. Next is concession theory, which is an extension of fiction theory, which simply says that corporation is a fiction by the creation of by the law, which means a corporation has been created at the procedural form by the state. So all its rights and duties are determined by the state, and it function according to the laws made by the state, and therefore there is no ground of mischief. Real theory of the corporate personality, which says that corporation is not creation of any fiction. It is in a real sense because it is run by natural human beings who have real mind, real will, and real power. So if any crime is committed by the corporation, which means these human beings have committed the crime within the ambit of the corporation. Next, we studied bracket or symbolist theory, wherein we said that corporation is an artificial juristic person runs by natural human beings, but these human beings or the mass of or groups of human beings are kept within the ambit or bracket of the corporation. So once they commit crime, this bracket is removed and they are out from the corporation. Next theory was of Hoffield theory. Hoffield also gave a distinction between juristic and natural person, wherein it was also an extension of bracket theory itself, wherein he said that the personality of a corporation is being formed by the procedural form, and that procedural form is the procedure of laws, rules of procedure made by the state. So these rules of procedure are the ambit or bracket of the corporation, and within them the natural human beings perform their activities, or you can say perform their acts with their real mind, real will, and real power. Next is Kelson theory. Kelson theory satisfied the point on the difference between juristic and a natural person, wherein he said that a natural person is one entity which have the claims of rights and duties. Turning to corporation, he said that these conducts of human beings are within the corporation are subject to the rights and duties of the corporation. This again we can say that is an extension of a bracket theory. That means corporation is the bracket within the conduct of human beings help to carry out the subject matter of rights and duties of the corporation. Thus, the existence of corporation requires a legal framework and a body of law that grants it personality, which means rules of procedure which grants the personality to a corporation, whether it is artificial juristic person, fictional person, or legal person. Finally, expressing the views about two aspect theories of legal personality, we can come to a point that corporation is neither wholly fictitious nor wholly real. It is instead, we can say it is partially fictitious and partially real. However, this assertion serves with a useful purpose of determination of rights and duties of corporate entities of legal person. One, each theory of duties imposed by the state are the same, and the persons on whose actual wills and duties are imposed are the same. Hence, it would not be incorrect if contended that difference between fiction theory and realist theory is merely verbal. So if we conclude the point that a corporation being an artificial juristic person is partly fictitious and partly real. With this aspect, we have completed the concept of legal person, its nature and concept, wherein we studied the definition of legal person given by Salmon, Savigny, Dicey, and Gray. Then we studied the nature of legal person, two kinds of person, that is natural and legal. Then we studied the origin of legal personality, wherein we studied the legal status of different aspects, that is legal status of unborn child, of dead person, of animals, and of idol and mosque. Then we studied the concept of legal personality, which means what are the theories which determine the concept that an artificial juristic body would also have the attributes of legal person, wherein we studied first the meaning of corporation, kinds of corporation, and then different six theories, that is fiction, concession, realist, bracket or symbolist, Hoffield, and Kelson. With this, we come to a conclusion that a legal person also have an attributes of a natural human beings, which means any such person who have an attributes of that of natural human beings which have been recognized by law are termed as legal person, and the attributes of rights and duties of this legal person are determined by various theory, which comes to a conclusion that an artificial juristic person, a corporation, can neither be wholly fictitious or wholly real. It is partly fictitious and partly real, which means its rights and duties are determined by the law, that is the state, and the human beings perform these rights and duties with real power, real will, and a real state of mind. And within this ambit of the person, they perform the rights and duties which create the aspect that these artificial juristic person, that is corporation, have their attributes of the personality as per the rules of procedure recognized by the state and law. Dear students, with this we have completed the revision of our first unit of Jurisprudence 1. Hope now the aspect of legal personality is more clear to you with the aspect of the revision class. Another point is that I would be forwarding you the necessary notes and PPTs wherever necessary. I request you student to please go through the notes, PPTs, listen to the lecture carefully, Any doubt further, you can contact me on my mail ID. Further, as we have not done any single assignment of any of the units which we have already completed, so let's begin our series of assignment, wherein I would be submitting you an assignment on the topic of legal person, nature and concept, that is unit 1. And I request you people to do the assignment on time and submit it with diligent work. Thank you and have a good day.